Welcome to a masterclass in judicial architecture. The legal framework of a nation doesn't just happen by accident, it is engineered. Today, we are opening the master blueprint of India's judicial system to dissect the structure, authority, and mechanical design of the High Courts of India, built strictly upon the constitutional grid of Articles 214 to 231. Every grand structure needs an unshakable foundation. Under Article 214 of the Indian Constitution, the law declares, there shall be a High Court for each state. Positioned deliberately within Part V of the Constitution, these institutions act as the absolute highest judicial authority at the state level. They are the structural anchors of India's integrated, single judicial pyramid. The evolution of this network is a story of deliberate structural expansion. The foundations were laid back in 1862, with the historic establishment of the Calcutta, Bombay, and Madras High Courts. By 1866, expansion built the Allahabad High Court. Before independence, 11 colonial provinces operated with their own distinct courts. Fast forward to the modern era, 2013 brought a vital northeastern addition with new courts for Tripura, Manipur, and Meghalaya. Today, the blueprint stands complete with 25 high courts operating across the country, the 25th being the High Court of Andhra Pradesh. But how does a vast nation balance efficiency with local access to justice? Enter Article 231. The 7th constitutional amendment in 1956 introduced a brilliant structural shift, allowing Parliament to establish a common High Court for two or more states. Look at the map. The Bombay High Court covers Maharashtra, Goa, and the territories of Daman, Diu and Dadra Nagar Haveli. The Guwahati High Court unites Assam, Arunachal Pradesh, Nagaland, and Mizoram under one roof. From Punjab and Haryana to Calcutta and Madras, shared courts maximize regional stability and legal unity. Who is qualified to occupy the bench of a High Court? Article 217 lays out the mandatory engineering tolerances. First, the absolute baseline, they must be a citizen of India. From there, they must successfully clear one of two pathways. Pathway A, the judicial route, requires a minimum of 10 years holding judicial office within a subordinate court. Pathway B, the advocate route, requires 10 years of active practice as a High Court advocate. Interestingly, unlike the Supreme Court, the exact number of judges on a High Court bench isn't locked down by the Constitution. It is dynamic, determined entirely by the President of India based on caseload requirements. The appointment process is a meticulously calibrated machine designed to protect judicial independence. The ultimate appointing authority is the President of India. But the process requires deep consultation. First, the President must consult the Chief Justice of India. The CJI, in turn, consults the Supreme Court Collegium consisting of the two senior-most judges. Next, local consultation occurs with the governor of the respective state and the sitting Chief Justice of that specific High Court. Once selected, the judge takes their official oath locally, administered by the state governor. If a judge needs to be transferred to another High Court, the machinery shifts to an expanded 5-member collegium, consisting of the CJI and 4 senior Supreme Court judges, alongside consultation with the Chief Justices of both the transferring and receiving courts. Once appointed, High Court judges hold office until the strict retirement age of 62 years. Safeguarding their independence means removing a judge requires navigating a formidable legal gauntlet. The removal process perfectly mirrors that of a Supreme Court judge, strictly limited to 2 grounds: proven misbehavior or total incapacity. If charges are brought forward in Parliament, a strict 3-member investigation committee is formed, comprising a Supreme Court judge, a High Court Chief Justice, and an eminent jurist. If found guilty, the motion must cross the ultimate threshold, passing by a special majority in both houses of Parliament before the President can issue the final removal order. Let us look at the structural architecture of High Court power. Its complete authority is supported by 4 distinct operational pillars: original jurisdiction, acting as the court of first instance; appellate jurisdiction, processing appeals from lower courts; writ jurisdiction, protecting fundamental rights; and supervisory control, overseeing the lower courts. Supporting all 4 pillars is the deep structural bedrock of judicial review, the immense constitutional power to strike down unconstitutional legislation. Let's isolate Pillar 1, original jurisdiction under Article 225. This allows the High Court to hear cases directly from the start. Its core jurisdiction handles critical issues like marriage, divorce, succession, company law, and the enforcement of fundamental rights. It also resolves specialized political and economic disputes, such as contested elections of MPs and state MLAs, alongside revenue collection conflicts. For major economic hubs like Delhi, Madras, Calcutta, and Bombay, the high courts retain original jurisdiction over high-value civil cases. Note this historical shift: their historical original criminal jurisdiction was entirely abolished in 1973 to streamline the legal process. Pillar 2 regulates the massive upward flow of legal appeals from subordinate courts. The civil pathway is split cleanly into two: first appeals, which re-evaluate both questions of law and questions of fact, and second appeals, which are admitted strictly on substantial questions of law. The criminal pathway handles severe matters. Any lower court case involving imprisonment of more than 7 years can be appealed here. Most importantly, look at the mandatory review fail-safe. Any death sentence awarded by a district session court cannot be executed until it is explicitly reviewed and confirmed by the High Court. Additionally, appeals against decisions from administrative tribunals flow directly into the High Court's division benches. Pillar 3 represents the most dynamic machinery of public protection: writ jurisdiction under Article 226. Think of writs as specialized constitutional commands. Habeas corpus demands the immediate production of an illegally detained person. Mandamus serves as a direct command compelling a public official to perform their duty. Prohibition stops a lower court from exceeding its legal boundary, while certiorari calls up a lower court case to review or quash its order. Finally, quo warranto challenges the legal authority of someone holding a public office. The Supreme Court ruled in the landmark 1997 Chandrakumar case that this exact writ jurisdiction is an immutable part of the basic structure of the Indian Constitution, meaning it can never be destroyed or stripped away. This brings us to one of the most fascinating paradoxes in constitutional engineering: the High Court actually possesses a wider writ jurisdiction than the Supreme Court itself. Let's look at the data matrix. While the Supreme Court can only issue writs to enforce fundamental rights under Article 32, the High Court under Article 226 can issue them for fundamental rights and any ordinary legal right. Furthermore, during a national emergency, Article 32 can be suspended by the President, temporarily pausing the Supreme Court's writ power. Article 226, however, cannot be suspended. The High Courts retain their full writ powers even in times of crisis. The only area where the Supreme Court leads is obligation. Because Article 32 is itself a fundamental right, the Supreme Court is legally bound to hear a writ petition, whereas the High Court's remedy remains a matter of judicial discretion. Pillar 4 cements the High Court's institutional authority. Under Article 215, it acts as a permanent court of record. Every judgment it delivers is recorded for perpetuity and stands as a binding legal precedent for all lower courts within the state. To protect this authority, it holds the power to punish for contempt of court, with penalties reaching up to 6 months of imprisonment, a fine of 2,000 rupees, or both. Finally, its power of judicial review under Articles 226 and 13(2) allows it to declare both legislative acts and executive orders completely null and void if they violate the Constitution. While the 42nd Amendment historically tried to curtail this oversight over central laws, the 43rd Amendment fully restored it, preserving the balance of power. The High Court doesn't just judge, it manages. It exercises complete administrative control over the entire network of subordinate state courts. Directly beneath it sit the district and session courts. The governor appoints these judges, but strictly in consultation with the High Court, requiring candidates to possess a minimum of 7 years of experience as an advocate. Branching further down the organizational tree are the subordinate judges and local municipal courts. At the very grassroots level sit the Gram Nyayalayas, established in 2009 as mobile courts for rural justice. The state governments appoint their first-class magistrates, but only with the strict permission and oversight of the High Court. Unlike federal nations like the United States, which run separate state and federal court systems, India's blueprint engineered an integrated judiciary. In this design, the High Court acts as the vital structural linchpin. It enforces downward constitutional discipline and administrative supervision over the vast network of lower courts, while acting as a vital filter for the Supreme Court above, resolving state disputes and elevating only the most critical substantial questions of law. A true marvel of constitutional engineering, designed to keep justice unified, independent, and accessible for over 1 billion citizens. Don't forget to subscribe, like, share, comment if you enjoyed this quick revision.